Okay, so I was in the middle of explaining the view of the Riv, and I'm actually going to start reading it from the beginning. V'chatava Rav Alfasi Zal v'Periket Pashut. Rav Alfasi explained in the last chapter, I believe, of Bava Batra. Uchidvarav near end. The Ran adds, I think what he says is correct. She'ein esek lebeitin chashuv b'tnain shebein adam lechavero. If it's just a private arrangement between two people, like if I don't work the field, I'm going to pay you a fine of 1,000 zuzim. So in that case, if I made a kinyan me'achshav, even though in general asmachta is a problem, there the asmachta is not a problem because there was a maseh kinyan and the kinyan was me'achshav. So it really wasn't an obligation; it was a transfer of the money under certain conditions. And there, even though we would say it's not rational for a person to do it, or it's an act of desperation, and therefore not truly meant, the sale, the transfer is valid. So in those cases, all you need is kinyan me'achshav. Aval hacha, but in this case where the person has placed his documents and proofs and given it to the safekeeping of the courts, and has said, if I don't return by a certain time, let my claims be null and void. Davka ka'amar, here it specifically said that you need a beit din chashuv. Mishum dahai gabra lo midate bilvad amar di lo ati lebatlan schute. This person did not of his own free will say, if I don't come by a certain time, let my rights be canceled. Ela Beit Din hiskiku l'kach. Beit Din requires him to do so because Beit Din wants the issue to be resolved. They don't want it to drag on. So they say, if you want to make your claims, you have to do so within a certain period of time. So therefore, he's forced into saying, okay, I'm giving you the documents, and if I'm not back in 30 days, let's forget the whole thing. So in that case, Mishum Hachi, this is why Davka ki kanu miyade Beit Din chashuv. That's why in this case we need that the Beit Din acquired from this individual this commitment that the obligations would be, the claims would be canceled in 30 days, and it has to be a Beit Din chashuv. Now here's basically where I left off, and now the Ran adds something interesting, and he says, Af al gav de lo amar me'achshav, even though me'achshav was not said. That is, in the other cases where we've said kinyan works to mitigate the effects of the presence of asmachta, that is only when the kinyan is me'achshav. So the fact that I'm making a commitment to a kinyan from this moment mitigates the effects of asmachta. But here you don't require even me'achshav. If kanu miyade and there was nothing said about me'achshav, nonetheless, the asmachta is mitigated. Why? The Beit Din chashuv alim lavkue mamona. Because a Beit Din chashuv is a very powerful court, and they have the ability to take property, money out of the hands of individuals. And so once you give the power to the court to hold your documents, even though you didn't say me'achshav, from now you have put your documents in the hands of a powerful entity, which is considered to have the power under any circumstances to act in accordance with the conditions that were made, even though they smack of asmachta. Now, this section of the Ran concludes with a question, a difficulty, and the difficulty is as follows. Why do we need a Beit Din chashuv here? In a way, we're circling back to the original question, where we said that in general, kani me'achshav is sufficient. So why is a Beit Din chashuv? Why do we need this factor? Take ifle, dikanu miyade. Because why don't we simply say there was a maseh kinyan, V'chol kinyan me'achshavhu. And every kinyan, by definition, is me'achshav. In other words, what is the Ran? What did he say previously, and what was problematic about that? Which is the problem that he's raising now. Before, he was suggesting that the reason that Beit Din Chashuv was required was that it was the Beit Din that was insisting on this arrangement, and why did it have to be Beit Din Chashuv? So that even if he made a Maaseh Kinyan but he didn't commit Me'achshav, the Beit Din, being a Beit Din Chashuv, has the power to enforce the arrangement under any circumstances. And so now the Ran is asking, but wait a minute, every Maaseh Kinyan is a Kinyan Me'achshav. And if it is every Kinyan is a Kinyan Me'achshav, then even in this case of the shtarot being held by the courts, no Beit Din Chashuv should be needed. So that's his question. He says, V'chol kinyan me'achshavhu. Why? Ihashta lokani batar hachi lokani. Because when you do a maaseh kinyan, and what kind of maaseh are we talking about? Kinyan sudar, let's say, which is what we're talking about here. If it's not effective from the moment of the maaseh kinyan, then there's not going to be any chalut kinyan later on. The hahadra sudra lamare, because the instrument of acquisition is no longer in the hands of the acquiring party. So therefore, the Maaseh Kinyan, remember, and he says, this is Kedivrei Rabbeinu Tam, because we encountered this earlier, that if there was a transaction, if the consequences of the transaction were not visible, we could say, not discernible through the facts on the ground, then there is no Maaseh Kinyan. So here, you're making a Kinyan with a Sudar, but the Sudar does not remain with the person who took it, returns to the original person. And now you're saying at a later moment the Kinyan can take effect. It can't take effect because there is a disjunction between the Maaseh Kinyan, which no longer is present in any shape or form, and the Chalut Kinyan, the moment when you want the Kinyan to take effect. Right? So he's saying, by definition, every case of Kanu Miyado must be Me'achshav, because otherwise the Kinyan Sudar is a nonsensical act. And once you say that every Maaseh Kinyan is a Kinyan Me'achshav, and we've said that every time there is a Kinyan Me'achshav, there's no problem of Asmachta. So in the case at hand, once the person made a Kinyan saying, committing to canceling that person's claim in 30 days if he didn't return, what is the need for the Beit Din Chashuv? And so here is the answer given by the Ran. In true, Vadai Kushta Ka'amar. It is true. Shemi shechnesa de lechavero stam v'kanu miyadei, that if I sell my field to you, and there was a Maaseh Kinyan, we understand, and again, let's say it's a kind of Maaseh Kinyan, like a Kinyan Sudar. It is true that the Kinyan, by definition, begins in that moment. Even if there's a Tanai, some condition that has to be fulfilled, but the Kinyan, by definition, will be retroactive from the moment of the Maaseh Kinyan. Aval, ki atne im lo bati, but in a case where a person says that this canceling of my claims will take place only if I do not return, lo mashma delikne me'achshav, does not sound as if the person is saying that the debts are being canceled now. It sounds as if the person is saying, I'm willing to cancel my debts, but only in the future if I do not return. Right? Ella, rather what it sounds like, I just explained it, but now I'll read it. Rather what it sounds like, lebatar hahu yoma. It sounds like the cancellation is only meant to take place after the day on which the Maaseh Kinyan takes place. V'nimtza she'eino koneh klal. And then it turns out that the maaseh kinyan, if the intention was that the kinyan should take effect, the kinyan that's being performed today, the kinyan sudar, should only take effect after 30 days, in fact, that can't happen. And the maaseh kinyan would be ineffective. So in this case, then, we have the creditor performing a maaseh kinyan, through which he wants to obligate himself to cancel debts at a future time. And a maaseh kinyan of this kind does not have the power to effect a cancellation of a debt at a future time. So how do the debts get canceled? Ela mishum hachi sagi hacha b'kinyan stama. So yet we allow a maaseh kinyan here, even though the commitment is only for the future. So we allow the maaseh kinyan without the me'achshav commitment. Mishum de beit din alime lavkue memona vehave me'achshav. Because since the court always has the power to collect money, to claim money from any individual, therefore, in effect, he has given up his rights, at least potentially, from this moment, because at any given moment, the Beit Din has the power to transfer ownership from one person to another. And this is the principle that's mentioned a few times in the Talmud, Hefker, Beit Din, Hefker. Beit Din has the power to render property ownerless, meaning it has the power over ownership in general and can dispose of property that belongs to person X and say that now we're transferring ownership to person Y. So without going back through all the twists and turns of the Ran, what is important here is that normally, when we are talking about a maaseh kinyan that is going to take effect immediately, mitigating the effect of asmachta, we are talking about the transfer of property or money from one party to another. And that can take effect and is considered valid even in the face of asmachta, as long as the commitment is now, and then of course that there was a maaseh kinyan. But in the case that we are discussing, and it can be said more precisely, but we're not going to get too much into it, we're not really talking about transferring ownership of a particular object or document. We're talking about canceling a debt. And this is something that is being made dependent on the powers of the court. And it's not actually taking place at this moment. It's something that will happen in the court, that the court will declare that these debts are null and void. And therefore, you have to have a court that is powerful enough to do it and powerful enough to do that at any given moment. So that there is a maaseh kinyan here, but there's not necessarily intent on the part of the creditor. Let me say it differently. There's not an obligation. There's not a commitment on the part of the creditor to cancel the debts retroactively, me'achshav. But it doesn't matter because he's placed these documents in the care of the courts, and the courts have a lot of latitude in deciding if and when to cancel debts.